So thank you very much. Actually, I heard with great interest the Uranovit arbiter part, which I was intending to refer perhaps in the second round. I will start with the party autonomy because that was actually highlighted by Professor Kalavros in his introduction as well. And party autonomy is indeed key in international arbitration, but it can neither be absolute or operate in a vacuum. So in this respect, I think the New York Convention also sets out the restrictions and the ground by stipulating the grounds on which recognition and enforcement of an arbitral award can be challenged. So in this respect, I heard with great interest also Professor Besson's highlighting the fact that the role of mandatory rules in international arbitration is uniquely complicated, especially because it brings the interests of the parties and the states in particular conflict. And from a practitioner's approach, I would like to highlight especially some policy considerations since the topic of our panel is very generic, but I think these policy considerations can lay the ground for the discussion going forward. So, first of all, any dispute resolution mechanism is helpful and successful insofar as it can be consistent. It can offer predictable results and outcomes for the parties. And the issue is that with the analysis that Professor Besson and the keynote speakers and also the commentators have raised, the views on mandatory rules and their applications can actually challenge such consistency. Second, as Professor Eleni stated, there is an interest on the part of the states to secure their position, and especially when it comes to arbitration, if they believe that their position and their interests are better safeguarded by mandatory rules, they will have an incentive to overregulate. And we can easily see how this can act counterproductively, both in arbitration, but most importantly in economy and in business transactions. And then going back to the last point that was also referred to by Mrs. Mandakou, what the role of the arbitrator is. Is it the role of the arbitrator to protect the parties or the wider community by actually applying mandatory rules? And I think I agree that there are situations that the application of mandatory rules are uncontroversial. And these have to do with the force majeure, as Professor Besson stated, international public policy, and probably the mandatory rules of the lex contractus. I don't want to refer more on those. There is, of course, a long also controversy on whether the laws of the seat of the arbitration should direct us to further mandatory rules and how this would play out. In this respect, I also think that from a practitioner's point of view, it is very important to make sure that the validity and the enforceability of the arbitration award will be protected. And I also believe that even institutions like ICC have provided in their rules grounds on the basis of which we can actually see that these rules should also be taken into account. For example, the 2021 rules, ICC rules provide that the ICC court in its scrutiny has to use its best efforts to also look into the law of the seat of the arbitration. So, in my view, and in this first round of comments, the integrity of international arbitration lies upon the arbitrators' respect of the state interests, of the public policy, and for this reason, arbitrators would need to balance the respect of the party autonomy with the need to apply mandatory rules, of course, in a narrow scope and insofar as their powers and duties allow them to. Now, the issue is a little bit more controversial when it comes to third country mandatory rules. And without wanting to take more time, a last point on that would have to do, of course, since we are in the Athens arbitration days and in the European territory, the limitations to the party's autonomy as enshrined in Articles 3 and 9 of Rome I regulation, which is a very controversial topic because it has been supported that basically Rome I regulation doesn't apply to arbitration. My personal view is that Rome I regulation does not apply to arbitration agreements, but I could hardly see how one could not take into account the overriding mandatory rules as provided for in Article 9, when, of course, the case is relevant and when it makes relevance to the particular case, especially from a standpoint that has to do with the challenge of the potential award that would be issued if Article 9 of Rome I regulation is ignored. Also, taking note from the Eco-Swiss case, I would hardly see how we could exclude application of the Rome I regulation by the tribunals to apply. And to the contrary, I would see that basically the provisions of Rome I regulation can be easily supported, that they could be considered part of the lex contractus that has been chosen by the parties.
Thank you very much.